Now let's move on to Article 20, Protection in Respect of Conviction for Offences. We saw in the Rule of Law video that state can only punish a citizen for a breach of law. But how is the guilty to be punished? And what is the degree of punishment? The purpose of rule of law is to prevent arbitrary actions of state. Article 20 takes a step further in this direction. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. Now, what is arbitrary? If a person has done robbery, then he must be punished for robbery and not for some other crime like murder. And also, the punishment should be in accordance with the law and not like if a person has done robbery, then court makes him write UPSC exam. Now that's a very strict punishment, right? Let's see what is excessive. The punishment should be as laid down in the laws. So 3 to 10 years in jail as punishment for a robbery is fine, but it should not be like jail for 30 years. Article 20 contains 3 provisions: no ex post facto law, no double jeopardy, and no self-incrimination. Let's take a hypothetical example of this guy Gabbar. He is a government employee. He was caught taking a bribe. Now normally the punishment for such a crime is up to 2 years imprisonment. But the very next day Parliament passed a law and increased the punishment to 10 years. So now which punishment will be applicable to Gabbar? It is the first one, because Article 20 prohibits a ex post facto law. It simply means that a law does not apply to acts that are already done before the law was passed. In other words, a law cannot be applied retrospectively. Now, an important point to note here is that this provision applies only to criminal laws and not to civil laws or tax laws. So a civil law or a tax law can be applied retrospectively. For example, there was the famous case involving Vodafone regarding retrospective taxation. Now let's see what is double jeopardy. Suppose Gabbar is convicted of the offence and serves a jail sentence for 2 years. Now he cannot be punished once again for the same crime that he had committed 2 years ago, as this would mean double jeopardy, that is punishing twice for the same instance of crime. However, if he once again gets involved in bribery, then he will be punished once again, because this is another instance of crime, so it won't mean double jeopardy. Now note that double jeopardy doesn't apply to departmental or administrative authorities, as they are not of judicial nature. So Gabbar's department can punish him for the same crime in different way, like transferring him to a remote location. Now let's see what is self-incrimination. It means that it is not Gabbar's job to prove that he was involved in the bribery case. It is the job of the prosecution. He cannot be forced to be a witness against himself. Self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to compulsory production of material objects, compulsion to give thumb impression, specimen signature, blood specimens, etc. Further, it extends only to criminal proceedings and not to civil proceedings.